In recent years, there has been an increasing focus on how Title IX applies to transgender students. Some hot-button issues include schools' pronoun policies, bathroom policies, and transgender students in sports. Title IX prohibits discrimination based on sex in educational programs and activities that receive federal funding. Over the years, the interpretation of what constitutes sex-based discrimination has expanded and evolved. Take the pronoun use as an example. The U.S. Department of Education, under different administrations, has issued different guidance on whether protections based on gender identity, which would include pronoun use, are covered under Title IX. The Department of Education under the Obama administration interpreted Title IX to include gender identity, thereby extending protections to transgender students. This interpretation suggested that policies around pronouns and gender identity were indeed covered under Title IX. However, the Trump administration rescinded the Obama-era guidance, thereby creating uncertainty about whether the Title IX protections extended to gender identity. Next, the Biden administration has signaled a return to interpreting Title IX as inclusive of gender identity. Given the changing political landscapes and ongoing legal debate, educational institutions should stay informed about the current federal guidelines and the legal precedent. Here I introduce recent cases on pronoun policies, bathroom policies, and transgender students in sports. In the case of Foote v. Ludlow School Committee, the school district had a school policy that parents were not to be notified when their children raise issues of gender nonconformity or transgender status, request to be called by an alternative name or pronouns, or even use privacy facilities designated for the opposite sex. 4 parents sued the school, alleging that their constitutionally and statutorily protected rights to make decisions regarding the mental health of their children was violated when the school chose not to disclose their children's decision to establish a new gender identity at school. The case was filed on April 12, 2022, in the U.S. District Court for the District of Massachusetts. The court held that a school district's policy requiring staff to use students' preferred names and pronouns did not violate parents' rights under the 14th Amendment. The court dismissed the parents' claim that the school district's pronoun policies violated parents' rights to direct the education and upbringing of their children, along with their right to family privacy. That ruling is now on appeal at the U.S. Court of Appeals for the First Circuit. Here's a case that intertwines a university's pronoun policy and the faculty members' free speech and religious beliefs. The case Meriwether v. Hartop, 2021, unfolds at Shawnee State University in Ohio, where philosophy professors Nicholas Meriwether had a spotless disciplinary record. He was also a devout Christian, believing that God created human beings as neither male or female, and that this sex is fixed in each person from the moment of conception, and that it cannot be changed regardless of an individual's feelings or desires. Meriwether also believed that he could not affirm as true ideas and concepts that are not true. In 2016, the university introduced a policy requiring faculty to address students by their preferred pronouns. This policy was applicable to all faculty, regardless of their personal beliefs. Meriwether approached his department chair to discuss his concerns about the pronoun policy. Knowing that Meriwether had successfully taught a course on Christian thought for decades, the department chair said that Christians are primarily motivated out of fear and should be banned from teaching courses regarding that religion. In her view, even the presence of religion in higher education is counterproductive. Meriwether, known for his formal and respectful approach in class, traditionally addresses students as Mr. or Miss. This practice, he believed, was important for maintaining a serious academic atmosphere, especially in discussions on controversial topics in his political philosophy class. Meriwether continued to teach students without incident until January 2018. On the first day of class, Meriwether inadvertently addressed a student, Doe, who identified as female, as Sir. Unaware of Doe's gender identity, this was an innocent mistake on Meriwether's part. According to Meriwether, no one would have assumed that Doe was a female based on Doe's outward appearances. Meriwether responded to a question from Doe by saying, "Yes, sir." That was Meriwether's first time meeting Doe, and the university had not provided Meriwether with any information about Doe's sex or gender identity. After class, the student Doe confronted Meriwether, demanding to be referred to with feminine titles and pronouns. This was the first time that Meriwether learned that Doe identified as a woman. Meriwether paused before responding because his religious beliefs prevented him from communicating messages about gender identity that he believed were false. Meriwether explained that he was not sure if he could comply with Doe's demands. Doe became hostile, circling around Meriwether at first and then approaching him in a threatening manner. Doe promised that Meriwether would be fired if he did not give in to Doe's demands. Meriwether reported the incident to senior university officials, including the dean of students and his department chair. University officials then informed their Title IX office of the incident. Officials from that office met with Doe and escalated Doe's complaint to the acting dean of the College of Arts and Sciences. The dean went to Meriwether's office the next day. She advised that Meriwether eliminate all sex-based references from his expression, not using he or she, him or her, Mr. or Miss, and so on. Meriwether pointed out that eliminating pronouns altogether was next to impossible, especially when teaching. So he proposed a compromise to address Doe only by last name. The dean initially accepted his proposal, but later considered it insufficient. Despite Meriwether's efforts to respect Doe's identity, tensions continued to rise. Doe continued to attend and participate in Meriwether's class, but Doe remained dissatisfied, and 2 weeks into the semester, complained to the university officials again. The dean paid Meriwether another visit. This time, she said that if Meriwether did not address Doe as a woman, he would be violating the university policy. Soon after, Meriwether accidentally referred to Doe using the title Mr., and he immediately corrected himself. Doe again complained to the university's Title IX coordinator and threatened to retain counsel if the university did not take action. The dean again came to Meriwether's office. She reiterated her earlier demand of addressing Doe as a woman. The dean also threatened disciplinary action if Meriwether did not comply. Trying to find common ground, Meriwether asked whether the university's policy would allow him to use students' preferred pronouns, but placed a disclaimer in his syllabus, noting that he was doing so under compulsion and setting forth his personal and religious beliefs about gender identity. The dean rejected this option out of hand. She insisted that Meriwether must adhere to the pronoun policy without any public disclaimer of his personal beliefs. Putting a disclaimer in the syllabus would itself violate the university's gender identity policy. After the meeting, the dean sent Meriwether a letter demanding that he address Doe with the female pronouns, just like other female-identifying students. Non-compliance would lead to an investigation and potential disciplinary action. A few days later, without awaiting Meriwether's responses, the dean initiated a formal investigation based on another complaint from Doe. When Meriwether again asked whether an accommodation might be possible given his religious beliefs, the dean gave him two difficult options: either stop using all gender-specific pronouns or refer to Doe as female, conflicting with his religious beliefs. The dean referred the matter to university's Title IX office. Over the coming months, the Title IX office at the university conducted an investigation, interviewing only 4 individuals, including Meriwether, Doe, and 2 other transgender students. They did not ask Meriwether to recommend any potential witnesses. And aside from Doe and Meriwether themselves, none of the witnesses testified about a single interaction between the two. Still, the investigation concluded that Meriwether created a hostile environment by not acknowledging Doe's gender identity as defined by the university's policies. Meriwether's request for religious accommodation was not considered in the report. Following the Title IX report, the dean charged Meriwether under the faculty's collective bargaining agreement. The dean then issued her own report stating, because Dr. Meriwether repeatedly refused to change the way he addressed Doe in his class due to his view on transgender people, and because the way he treated Doe was deliberately different than the way he treated other students in the class, he effectively created a hostile environment for Doe. The dean concluded that a formal warning was recommended to be placed in Meriwether's file. Meriwether wrote to the provost, asserting his equal treatment of Doe and highlighting Doe's successful performance in his class. It's important to note here that Doe excelled and participated as much or more than any other students in the class. At the end of the semester, Meriwether awarded Doe a high grade. This grade reflected Doe's very good work and frequent participation in class discussions. Meriwether reiterated his religious convictions and requested accommodation. However, the provost upheld the disciplinary action without addressing Meriwether's concern. A written warning was placed on Meriwether's file, instructing him to comply with the university's policy on addressing transgender students. Non-compliance could lead to suspension or termination. The university faculty union filed a grievance on behalf of Meriwether, seeking to overturn the disciplinary action and allow him to speak in accordance with his religious beliefs. The university's provost, initially unsympathetic to Meriwether's religious-based objections to the pronoun policy, was responsible for deciding on Meriwether's grievance. In the hearing, the provost showed overt hostility. He repeatedly interrupted the representative and made clear that he would not discuss the academic freedom and religious discrimination aspect of the case. The union representative tried to explain the teachings of Meriwether's church and why Meriwether felt he was being compelled to affirm a position at odds with his faith. At one point during the hearing, the provost openly laughed. The provost was so hostile that the union representative was not able to present the grievance. The provost rejected the grievance. The next step in the university's grievance process was an appeal to the university's president. The provost, now acting as the interim university president, assigned representatives to review the appeal. The representatives agreed that Meriwether's action did not create a hostile educational environment but instead labeled it as deferential treatment and upheld the decision against Meriwether. Their rationale equated Meriwether's religious beliefs to hypothetical racism or sexism, which the university would not accommodate. Out of options at the university, Meriwether filed a lawsuit alleging violations of his First Amendment rights. The district court initially dismissed his claims, but the Sixth Circuit Court of Appeals reversed this decision, emphasizing the importance of free speech in academic settings. The court underscored the unique role of academic freedom in higher education, differentiating it from other public workplace settings. The court argued that stifling a professor's classroom speech would give universities excessive power to enforce ideological conformity, something constitutionally untenable. The court also noted that the U.S. Supreme Court's Garcetti decision does not apply to university environment. In Garcetti case, the Supreme Court held that when a public employee makes a statement pursuant to their positions as a public employee rather than a private citizen, their speech has no First Amendment protection. This is the argument used by lawyers for the state of Florida in their court filing to defend the Individual Freedom Act, also known as Stop Woke Act, which took effect on July 1st, 2022. On August 24th, 2023, over a year after the act went into effect, a three-judge panel for the U.S. Court of Appeals for the 11th Circuit heard argument in Florida's attempt to allow the law to go forward. I'll continue to follow the development of this case. Back to the Meriwether's case, the court used strict scrutiny to evaluate the university's actions. To meet this standard, the university needed to show that its actions both advanced a compelling interest and were narrowly tailored to achieve that interest. The university's rationale for disciplining Meriwether shifted over time. Initially, Title IX reported, and the dean stated that Meriwether created a hostile educational environment by violating the gender identity policy. However, during the grievance process, the university conceded that Meriwether had not created a hostile environment, but was instead accused of disparate treatment. Later, at oral argument, the university reverted to claiming it was a hostile environment case. This inconsistency suggested the possibility of a pretext for targeting Meriwether's religious beliefs rather than applying a neutral policy. When Meriwether first faced disciplinary action, he proposed a compromise to address the student Doe by last name without using pronouns. Initially, this accommodation was accepted by the dean, but was later retracted. The university's stance evolved to a position that disallowed any religious accommodation. The Title IX investigation into Meriwether's conduct was limited, interviewed only by 4 witnesses, and excluding non-transgender students from Meriwether's classes. The investigation did not fully explore interactions between Meriwether and Doe, nor did it address Meriwether's request for religious accommodation. The court determined that the university failed to demonstrate that its actions were narrowly tailored to serve a compelling interest. As a result, the court ruled in favor of Meriwether. Following the court's decision, it was reported that the university agreed to pay Professor Meriwether $400,000. Let's move on to bathroom policies. Here is a 2022 case. In Adams v. School Board of St. Johns County, Florida, Drew Adams entered the school district as a biological female in the 4th grade. By the end of 8th grade, Adams began identifying and living as a male, adopting male pronouns and using male bathrooms in public. In 2015, in 9th grade at Allen D. Meese High School, Adams encountered a policy issue. The school, with a student body of 2,450, provided male, female, and gender-neutral bathrooms. The school district's guidelines allowed transgender students to express their gender identities and use gender-neutral restrooms, but not the restroom corresponding to their gender identity if it differed from their biological sex. For purpose of this policy, the school district distinguished between the boys and girls on the basis of biological sex by referencing to various documents, including birth certificates that students submit when they first enrolled in the school district. The school district did not accept updates to students' enrollment documents to conform with their gender identities. Adams' biological female at enrollment was therefore required to use the female or gender-neutral bathrooms. The school district's decision to maintain the long-standing bathroom policy separating bathrooms based on biological sex while providing sex-neutral bathroom accommodations for transgender students was motivated in part by the issue of fluid gender, in which students may switch between genders with which they identify. Initially, Adams used the male bathrooms in violation of the bathroom policy without issue. However, some students complained to school officials. The school then informed Adams that under the bathroom policy, Adams had to use either the female bathrooms or the sex-neutral bathrooms. Adams took issue with that directive and with parental help began petitioning the school to change its policy. After unsuccessful attempts to change the school's policy, Adams filed a lawsuit in 2017. The lawsuit claimed that the school's bathroom policies violated the Equal Protection Clause and Title IX. At the time of the lawsuit, Adams, still a teenager, had not undergone gender reassignment surgery but had taken steps toward transitioning, including hormone therapy and breast tissue removal. The district court ruled in favor of Adams, finding the school policy in violation of the 14th Amendment's Equal Protection Clause and Title IX and awarded Adams $1,000 in damages. And this decision was later affirmed by a divided panel of the 11th Circuit Court of Appeals. In response to a motion for reconsideration, the court re-evaluated the case. On December 30, 2022, the court issued a 7-4 decision upholding the school district's policy of separating bathrooms based on biological sex. The court held that the school district's policy of separating school bathrooms based on biological sex was constitutional and did not violate Title IX. Adams argued that the policy violated the Equal Protection Clause and the Title IX as it prevented Adams, who identified as male, from using the male bathrooms. However, the court disagreed. The court reasoned that the protection of students' privacy interest in using the bathroom away from the opposite sex and in shielding their bodies from the opposite sex is obviously an important governmental objective. The school district has a legitimate interest in protecting student privacy, which extends to bathrooms. All individuals possess a privacy interest when using restrooms or other spaces in which they remove clothes and engage in personal hygiene, and this privacy interest is heightened when persons of the opposite sex are present. And the school district's bathroom policy is substantially related to the government's goal in protecting student privacy interest in school bathrooms. The school district's policy did not discriminate on the basis of biological sex, nor did the policy discriminate against transgender students. The school district's bathroom policy facially classifies based on biological sex, not transgender status or gender identity. And both sides of the classification, biological males and biological females, include transgender students. To say that the bathroom policy singles out transgender students, mischaracterizes how the policy operates. A policy can lawfully classify on the basis of biological sex without unlawfully discriminating on the basis of transgender status. Also, the school district's bathroom policy separates bathrooms based on biological sex, which is not a stereotype. Recognizing the biological differences between male and female is not a stereotype. To accommodate 16 transgender students while protecting the privacy interests of 40,000 students in the school district, the school district authorized the use of sex-neutral bathrooms, which was not a special burden on transgender students. As a result, the court concluded that there is no evidence of purposeful discrimination against transgender students by the school district, and any disparate impact that the bathroom policy has on those students does not violate the Equal Protection Clause. The court also concluded that the Adams Title IX claim failed because Title IX allowed schools to separate bathrooms by biological sex. That is exactly what the school district has done in this case. It has provided separate bathrooms for each of the biological sexes. And to accommodate transgender students, the school district has provided gender-neutral bathrooms, which Title IX neither requires nor prohibits. Nothing about this bathroom policy violates Title IX. Whether Title IX should be amended to equate gender identity and transgender status with sex should be left to Congress, not the courts. Another area at the crossroads of Title IX and transgender students is transgender students in sports. Here I introduce a 2022 case, Soule v. Connecticut Association of Schools. In this case, since the 2013 to 2014 school year, the Connecticut Scholastic Athletic Conference has applied a policy that permitted high school students to participate on gender-specific sports teams consistent with their gender identity. The policy expresses a commitment to providing transgender student athletes with equal opportunities to participate in its athletic programs consistent with their gender identity, and concludes that it will be fundamentally unjust and contrary to applicable state and federal law to preclude a student from participation on a gender-specific sports team that is consistent with the public gender identity of that student for all other purposes. As a result, a student's eligibility to participate in the athletic association's gender-specific sports team is based on the gender identification of that student in current school records and daily life activities in schools and community. 4 cisgender female track athletes found themselves competing against 2 transgender students as allowed by the Athletic Association's policy. In February 2020, they sued against the Athletic Association and its member high schools, arguing that competing against transgender athletes deprived them of fair opportunity to win state titles. They also alleged that, among others, that the policy violated Title IX by failing to provide competitive opportunities that effectively accommodate the ability of girls and equal treatment, benefits, and opportunities for girls in athletic competition. The Second Circuit Court of Appeals in New York upheld the dismissal of the lawsuit. It noted that the Office for Civil Rights never clearly provided that allowing transgender students to participate on athletic teams consistent with their gender identity violates Title IX. However, Title IX's prohibition on sex discrimination has been increasingly understood to include gender identity, although this interpretation has been fluctuated with the changes in presidential administration in 2016 and 2020. The court noted the lack of clear legal protection or guidance at the time the policy was implemented and the Athletic Association's policy did not violate Title IX. It's important to point out here that the court did not make a definitive ruling on whether the pro-transgender policy should be upheld under Title IX, but it did seem to agree with the interpretation that the Title IX protects transgender students. The cases I introduced in this video highlight the evolving interpretation and application of Title IX, particularly regarding pronoun policies, bathroom policies, and the participation of transgender students in sports. For educational administrators in both K-12 and higher education settings, it's important to stay informed and adapt policies that are inclusive, fair, and compliant with federal law. The evolving legal landscape presents a unique challenge. How can administrators effectively balance the diverse needs and rights of all students while navigating the complexities of Title IX, ensuring that every student has an equal opportunity to thrive a safe and supportive educational environment? Feel free to leave your comments below. Thanks for watching. I'll see you next time.